Justice Kavanaugh pointed out in his colloquy with Ms. Blatt that these kinds of suits might be an important tool in the executive's toolkit. Could you explain why? I mean, given that the government has the authority to prosecute the individual, like, the executives at the bank, given that the executive is not going to prosecute the country itself, you say. So what is, I just want to understand the backdrop. What does the government get out of going after the bank as opposed to all the individuals who work in the bank?
Sure, Your Honor. A few things. First of all, the individuals, as a couple of the individuals are in this case, may be beyond our reach or missing. You could imagine a hostile foreign government acting through one of its corporations that just rotates people in and out and withdraws them and won't extradite them for us. More generally, what this does is force a change in the corporation as a whole or potentially disable it. The kinds of penalties we can seek under the criminal provisions would allow a penalty of up to 2 times the amount involved in the money laundering. But
if it's a hostile government, why are they going to cooperate with any of that? And why can't you just impose sanctions or use other tools?
Well, Your Honor, a couple of points. First of all, the other criminal remedy I was going to mention is potential forfeiture of all the assets involved in the offense. And if that were imposed potentially as a condition of probation or something to that effect, then that would enable the United States to essentially disable the petitioner bank from doing various things within the United States. As for other potential remedies, under the civil remedies, which I believe are 50 U.S.C. 1703, in order to impose fines for that or civil sanctions for that, we'd have to trace each transaction, which is going to be incredibly difficult in the context of a money laundering scheme where the specific purpose is to hide it. And we'd have to go through transaction by transaction. And the other problem is some of these remedies are sledgehammers. Some of the remedies they propose, up to and including going to war with Turkiye, are not things that would have very destabilizing consequences. And what we want to do is to deter other government-owned corporations from these kinds of actions, deter, frankly, other governments from trying to use corporations to do these kinds of things. I'm not saying that that's what happened here, but just hypothetically. And also just to disable this particular bank from doing the kinds of commercial activities potentially that it was engaging in that led to this prosecution.
What about the retaliatory consequences that Ms. Blatt points out could result in the other ways? The United States is not concerned about those, about foreign countries initiating criminal actions against U.S.-owned corporations?
A couple of points on that, Your Honor. It's not like we undertook this lightly. As I've said numerous times, we have considered that possibility, without
well, I understand that, but I think part of the questions that you've been getting about states is that however carefully the United States might consider it before initiating such a prosecution, it may or may not be possible to control what states and municipalities do.
And that leads to exactly the second point I was going to make, Your Honor, which is we never controlled what they were going to do. Now, if they decide, I don't know, this will enable them, to the extent that we have government-owned corporations that look like petitioner here, they will be able to point to this and other cases that we've already brought, potentially, and some of which have been resolved, like the recent Petrobras case in Brazil, as precedent for whatever proceeding they wish to undertake. But even before that, they weren't necessarily beholden to our view of the law in the first place. But we acknowledge that what's good for the goose is good for the gander. We've considered that, and we're prepared to deal with it. many of the instrumentalities that might be at issue in those cases, or actually they wouldn't really be instrumentalities, they'd be corporations, don't do a great deal of operation outside the United States. For example, if the government bailed out GM by buying 75% of its stock, we wouldn't be asserting that GM couldn't be sued in another country. We wouldn't view that as a suit against the United States.
Thank you.
I'm sorry, I said suit. What I meant even was prosecuted, and we wouldn't view that as a criminal prosecution against the United States.